Welcome to this meeting of the Environmental Control Board on this first hot day of 2016. Is there a motion to accept the minutes of the last meeting? Unless anyone has any questions or corrections or whatever. The minutes are accepted. Thank you very much. You are absent. First thing on our agenda today has to do with repeal of ECB's air quality penalty schedule, and Colleen Olson will give us a summary and ask some questions as to the hearing that was held in conjunction.
Good morning, everybody. I'm Colleen Balson, Deputy General Counsel for Oath. We have two final rules on the agenda today. The first concerns the repeal of the air code penalty schedule. The Department of Environmental Protection has promulgated an air code penalty schedule, which I believe went into effect on May 11th.
11th,
Yeah. So we need to repeal ours. In addition, the law department asked us to amend section 3-100 of the ECB rules, the oath rules, I'm sorry, to have the hearing officers look to the agency penalty schedules when they are adjudicating air code cases. We did have a public hearing. Several people showed up, but nobody testified on this rule. We have submitted a finding of substantial need for earlier implementation to City Hall. I don't know exactly when they are planning on signing it. We hope by tomorrow. Any questions? Yeah.
Is this all part of this program to repeal the ECB code sections and replace them with the rules that the individual agencies institute?
Yes.
Okay, I know we've got two things, and the second one is the general rules that we discussed last time.
Correct.
I'm referring to the air code thing. What's the rationale again for that? This particular agency?
So that this particular agency, well, I think the rationale applies to all agencies in that the enforcement agency is in the best position to determine the amount of the penalty for deterrence. And that the rulemaking will go much faster because they're enacting rules, then we are enacting a second set of rules concerning the penalties. So also it'll put the public on better notice because the penalties will be associated in the rules where the violations occur as opposed to having to go elsewhere. So that's the rationale.
For the record, I'll repeat what I repeated the last time. I think there's less transparency in this. I think it's a bad government initiative. I don't see why they cannot just cut and paste our rules and put it on their website. And the small delay in having a process and having a real review by, albeit 4 citizen members or 2 citizen members, as we have today, is one more step to ensure that the citizens have some input in rulemaking that applies to all of them. I also wish to make a motion to, at this point, to postpone this vote to the end so we can do the other issues that we have here, because I am prepared to walk out. And you will not have a quorum, but I do not wish to have the appeals and Russ and everybody else go without having a vote on it. So I have made that motion right now, and I think there will be a second.
So let me just add for the record that I think the repeal of these rules and the moving of them is flies in the face of good governance. It's undermining the public's the role that I was entrusted to play when I accepted this position, which was to represent the citizens of the city. Good governance means healthy debate. This is a solution in search of a problem.
That's a second, I take it.
That is a second. I would say that we don't want to upend the important other business that we do, and that we consider these 2 items at the end.
Anything else? Is there a motion to vote on the rules?
No, I made a motion to.
I understand you made a motion.
Are you not taking my motion?
No.
I'm leaving.
Can we wait to the end for this vote?
That's what I made a motion for.
You have a quorum?
No.
So I guess we don't have a meeting. This meeting is adjourned. And we'll see what the city council wants to do. Thank you for your time, folks. And I'm going to ask for a little bit of guidance here. The issue was raised that once we have a quorum, once we begin with a quorum, even if somebody leaves, we still had a quorum to begin the meeting. Does any, I'm looking forward to council, if they have any insight on that question. Off the record for a moment, review that question. We're going to ask for the assistance of the law department on that question. In the meantime, does anybody have a deck of cards?
Yeah.
We have a procedural issue with having the two members of so-called citizen members. Oh, can we lose somebody?
Yeah, Jorge, before, left when everybody else left, we've been calling him to get him back, and he hasn't been responding to his calls. So, we saw him.
Well, I'm 6.
In his office, maybe more at the city, maybe also.
So, he was one of the first to walk
Hmm?
out.
A quorum is 5.
Yeah.
It doesn't have to be made up of citizen.
No, it's supposed to be 5 with 2 citizens.
Right.
That's normal quorum.
And we started with the quorum.
We still have at least 5 regular board members plus the chair. Okay. Are we on?
Yes.
We have a procedural question. We will be asking the City's Corporation Council for guidance on it and as to the validity of what follows. The immediate research we have done is unclear as to what the answer is. So being that it is unclear, I want to leave the situation in a manner which will allow the Corporation Counsel's office to fully hash out where we're at, which is this. We began this meeting with a quorum. Quorum is defined in the charter, having a certain number of people from who are from the commissioners, for the city of New York, of 6 agencies and 6 appointees by the mayor from the public. There were 2 members of the public here this morning. They decided that since they appeared to be on the losing end of 2 votes, they would walk out and think that they would win by having a minority of 2 to 7. The question is, do we still have a valid quorum since we began with a quorum? That is the question that will be posed to the Corporation Council. We tried to reach them. There is no one available on this short notice. And we will find out eventually from them what their city's position is with regard to that. To allow them that the ability to proceed one way or the other, depending on what their research and conclusions come with, I propose that we vote on the 2 rules issues that were on today's agenda, and adjourn, and then find out from the Corporation Council how to proceed from there. We've had an introduction from the Deputy Commissioner, the Deputy General Counsel rather, on the proposal for repeal the Environmental Control Board penalty structure for the Department of Environmental Protection rules. The Department of Environmental Protection has, as it is authorized to do it, as has been determined after extensive research by the Corporation Council and others, that they can promulgate a penalty structure within their rule structure. Reason to revoke the existing rule schedule that exists in both ECB rules for ECB penalties is very simply because they are redundant and frankly no longer controlled, and there's no point in having them there. Presentation has been made on that right now, and for the record, and the Corporation Council can work on it. For the record, I move to adopt the revocation of the ECB air penalty schedule from oaths rules. Is there a second? Yeah.
No.
Okay. We have 1, 2, 3, 4, 5 in favor. It passes.
If I could,
Please.
I've got a focus. Yeah, this is a sensitive issue. The full board isn't here. We've had 2 board members walk out over this issue. I think this can be tabled till next time. Let's get some of the board's business done. The cease and desist orders for us, the pre-sealing reports, we can hear the judicial review, and then the work for the panel. That I think would suffice to get something done for this month and not address a very sensitive issue.
Well, I would just ask you a question as to why only the rules changes would be voted on today instead of everything, because either the law department is gonna tell us that all of it is valid or none of it is valid.
I agree. I think we should vote on the rest of the stuff. All right. If everybody's in agreement, it's all or nothing, basically.
I'm just trying to split the baby.
So for the record, with the existing members of the board present, the rule passes. The third item
So the third item is the proposed model rules, which will bring the environmental control hearing officers under the procedural rules for the hearings division. We did have a public hearing. We had 2 people attend, and we had actually 5 people attend. 2 people spoke. One of the people who spoke also submitted a written comment. In addition, we had 2 additional written comments, one of which didn't make sense, and the other, which we read very closely. We have made 6 changes to the rules as a result of all of the comments, some actually from DOB. In 3-12, which is a section that remains and is for ECB, we have changed board from the tribunal as authorized by the board. So we're trying to make clear where it's the board that's acting, as in you guys, and the hearing officers of the tribunal. So that was one change. We made a similar change to 3-18. We changed board to tribunal as authorized by the board in certain places. And we also eliminated the statement about the stipulation must be in the manner and form set by the board, because we couldn't decide if it should be the board or the tribunal, but nobody's changing the stipulations, so I don't know that that's really an issue. In section 6-01, we added a definition of the oath hearings division, which includes ECB, but made the definition of tribunal just the hearings division. 613E, we added only to confirm that a motion to amend a pleading, that there must be a motion to amend a pleading that a hearing officer cannot amend sua sponte. And in 6-17C3 and 6-19E3, again, we changed board to the tribunal as authorized by the board. So those were the changes. Everything else is the same from what it was when it was the proposed rules. Any questions?
New York County Lawyers Association testified as well?
They did. They were one of the people that testified. They were very much in favor of the rule changes. I think everybody got a copy of the transcript from the public hearing. It should have gone out with the board materials.
The purpose of these rules is to homogenize hearing procedures on administrative summonses across the city of New York. In too many instances, there have been contradictory and inconsistent rules depending on what division of oath somebody went to, which is a great considerable detriment to the public. At the same time, as many of us have heard, yesterday the City Council of the City of New York passed the Criminal Justice Reform Act, which ultimately transfers summons cases from criminal court to oath. Actually, what it does is it gives police officers the option of writing either to criminal court or to oath. What they envision, and frankly only time will tell, is that approximately at some point about 300,000 summonses that now go to criminal court will come to oath. These rule changes in part facilitate the administration of that function. A lot of work has been put into this with the Mayor's Office of Criminal Justice and the 16 agencies that actually 24 agencies, if you include all the tribunals, that feed summonses to oath right now. And particularly, a lot of this stuff has to do with IT and computer work that has to be, it's really a 5-year project among many agencies, particularly a lot of work being put in by the police IT people and both IT people and do-it IT people. And that's where this is at. And I move for adoption of these rules. Is there a second? and they're adopted by one.
Thank you.
Let's go through, the exercise on the cease and desist orders, preceding reports, and all the regularly scheduled stuff.
Must be required.
Yes.
Oh, really?
Russell Bakunis, Assistant Counsel with DEP. The department is requesting that the board approve, I believe it's 25 cease and desist orders this month relating to failure to install backflow prevention devices. All of these follow the same pattern as the requests that have been brought before the board on a regular basis. So the Department of Environmental Protection is asking the board to approve these 25 cease and desist orders.
Is there a motion? It's unanimous of all present.
The department.
With one abstention on
Yes, one abstention. The department is also requesting that the board approve a cease and desist order under the sewer code in the matter of Satan Restaurant at 702 Amsterdam Avenue in Manhattan. This restaurant was ordered in July of last year to install grease interceptors on 5 different drains. After a series of violations and commissioner's orders failed to result in compliance, the restaurant was ordered to appear for a mandatory compliance meeting with the Bureau of Wastewater Treatment on March 2nd, which they failed to appear for due to the continuing failure to comply. DEP is asking the board to issue an order to cease and desist.
Motion. Approved unanimously with one abstention.
And finally, under the noise code, the department is asking the board to approve a cease and desist order in the matter of Dell's Maraschino Cherries, which is located at 175 Dyckman Street in Brooklyn. This was a location that had become a little bit notorious a couple of years ago when it was raided by the NYPD. The Maraschino Cherry Factory was being used as a front for a marijuana farm, and during the raid, the owner of the business committed suicide. So it was in all the papers at the time. His heirs have continued the Maraschino Cherry business. One thing that is odd about the way that they're conducting the business is that they are not connected to Con Edison Power. The entire thing is powered by a giant Caterpillar generator, and it is the noise from that generator that is the subject of the cease and desist order. They have been cited for excessive noise from the generator on 4 occasions since last summer. It is still too noisy, and based on the continuing failure to comply with the noise code, DEP is asking the board to issue an order to cease and desist.
It's of no particular relevance, but what do they fuel the generator with?
I actually don't know. I actually received, I wasn't aware of this, except that I received a call from an attorney who's representing the complainants to find out when a cease and desist order was going to be issued. And he informed me that they have this generator because for some reason they're not connected to Con Edison.
I saw the photograph of the generator, and it seems like it's more expensive to fuel it than the Con Ed.
Yeah.
Anyway,
I don't have an explanation for that at this point.
it's very Ripley's, believe it or not, case,
Yes.
I think. Is there a motion? again, it's unanimous with one abstention.
Thank you.
And that's something to talk about over cocktails later on. That's truly weird. Thank you for the comic relief. Thank you for the comic relief. Needed something.
No problem.
Kelly?
Hi, Kelly Corso, Assistant Director of Adjudication Co. We have 39 pre-sealing reports today. In 17 of these cases, DEP is recommending, and the hearing officers are agreeing with that recommendation, that the C&D proceedings be discontinued. The basis of that is for either there was a review of the records by DEP or an inspection by DEP showing that the respondents have come into compliance or that they no longer own the site of premises. And for the discontinuances, 3 of them were sewer cases and 14 were backflow cases. The remaining 22 cases, the respondents did appear for hearings. In 19 of those cases, the hearing officers recommended no sealing or other action based on the respondent's evidence of compliance that was presented at the hearings. 4 of those cases were air code cases and 15 were backflow cases. And there are also 3 noise code cases. In 2 of those cases, the respondents provided evidence that there had been some work done to bring the site of premises into compliance. And based on that evidence, the hearing officers are recommending no sealing or other action, provided that the initial re-inspection and further re-inspection is within 180 days, showing a violation. And in the final noise case, the hearing officer is recommending sealing of the violating equipment. The respondent in this case is Prime 135 NYC LLC, and this involves a kitchen exhaust system at the respondent's restaurant located at 135 7th Avenue South in Manhattan. The respondent received a summons in January of 2015. No one appeared for that hearing, and the case went into default. The default order imposed penalty in order to forfeit compliance. The respondent did not comply, and DEP issued subsequent summonses for the same equipment in March and June of 2015. The respondent defaulted on both those summonses as well. DEP issued a final summons in October of 2015. A representative for the respondent did appear at the hearing, and he stated that the exhaust fan was going to be relocated so that it would comply with the noise code. The hearing officer did sustain the summons and ordered compliance forthwith. A subsequent inspection by DEP at the end of October 2015 showed the respondent still did not comply. So on January 28, 2016, the board approved a C&D order in this case. At the initial pre-sealing hearing on February 23, 2016, and in each of the subsequent pre-sealing hearings in March, April, and May, including the last hearing on May 17th, the respondent's representative did not provide any evidence of work done to bring the equipment into compliance with the noise code. And so based on the respondent's failure to present any evidence of work done, the hearing officer recommends that its kitchen exhaust equipment be sealed immediately.
Any other motion?
One abstention.
Unanimous with one abstention. So we'll now go into executive session and vote down a number. We're now back in public session. Is there a motion to adopt the Kingstown recommendations from the May 5th and May 23rd panels? And it's unanimous. Before we adjourn, I just want to make 2 points. Point number 1 is DEP's penalty structure went into effect on May 11th. That is the most recent and relevant penalty structure for DEP violations, and they are the controlling therefore the controlling penalty structure for those violations, and they will be treated that way going forward. The item that was on today's agenda for cleanup, which was removing the now arcane and non-functioning, essentially, penalty structure, legacy penalty structure from the ECB rules. It's a matter of cleanup. Yeah, but nevertheless, the controlling penalty structure is the penalty structure adopted by the Department of Environmental Protection for violation of rules of the Department of Environmental Protection, which is where they belong. Number two, this meeting commenced with a full quorum. At the time that the meeting was commenced, this was a legal meeting of Environmental Control Board, and despite two members walking out of the meeting, we still have a quorum, in my opinion, and the actions taken by the board since their departure are still valid actions of the board. Is there a motion to adjourn? We are adjourned.